So if I can start by, je veux vous souhaiter le bienvenue à tous et à toutes. I first want to say that today we are in organizational experimentation because we have a virtual audience as well. I want to say hello to several people who are watching from home, who are watching from other locations. And I want to tell those people that when we come to the question period, you will see on your YouTube window a place where you can ask questions, and we'll receive those questions and relay them to our speakers, okay? So this is part of the experience of our new institutional experimentation for better work project. My name is Gregor Murray. I'm the director of CRIMT, the Inter-University Research Center on Globalization and Work, and one of the lead researchers on this international project, which links 18 research centers across the globe on this theme of institutional experimentation for better work. It's a great, really honor for us to have the first seminar in this series with Professor Mary Crock and Professor Ron McCallum, who are longtime friends of ours, who are doing amazing work across the globe on a wide range of issues. Mary Crock is a very renowned professor and advocate of refugee rights. She is a professor at the Sydney University Law School, a prodigious author of multiple books and articles of all sorts, but she's also a very engaged and active researcher doing pro bono work on behalf of refugee rights, engaged in international projects on questions of migrants in different statuses, and of course, longtime husband and wife, Ron and Mary, their interests have linked up around the questions of migrants with disabilities. We have perchance here their brand new book, just published, The Legal Protection of Refugees with Disabilities, Forgotten and Invisible, question mark from the Edward Elgar Studies in Human Rights. They might mention this recent book shortly during the discussion, but I just want to highlight that it will be here and we'll have information about it available on the website. Now, our second speaker is well known to you because I think perhaps this is the first time that Mary speaks in a seminar, in a CRIMT seminar series, but certainly not the first time for Ron, who has participated in many of our conferences, published in our books, notably on citizenship at work, but a wide range of other seminars that we've held, many of which are available in the CRIMT media archives. Now, Ron is well known as a emeritus professor at the Sydney Law School, where he was dean. One of his many remarkable achievements was he was the first blind person to act as a dean, not only at Sydney Law School, but I think right across Australasia in this respect. Ron has also been very, very active on the UN committee, of which he was chair, on the rights of persons with disabilities, where he served several terms. So following up a UN treaty with national reports coming to the UN treaty on this question of rights with disabilities, of the disabilities and the rights of persons with disabilities. Now, there are so many other things we could say about Ron. Some of you might have seen his TED Talk on YouTube, and we certainly recommend it as inspirational. Recently, Nicolas Roby, whose wife works with children with special needs, says that she uses that YouTube talk with parents of children with disabilities to show them what is possible. And it's an inspirational tool that she uses on a regular basis with parents with whom she works. So it's a great pleasure to have you both here today, and it's a special pleasure because we're starting a long series on institutional experimentation, and when Ron flagged the idea that there's something in Australia called the Fair Work Ombudsman, or maybe somewhere ombudsperson, and that this has come to be something other than what we might have thought, and that you can angle this as well to the question of migrants with disabilities, then we thought we have a winner. This allows us to make the connection with some of the themes that we're interested in and how you experiment with mechanisms of regulation in relation to problems, and how actors, in a sense, in Australia are seeking to do this, often under difficult or unforeseen circumstances, and in our hope at least, where it can then become something else for more effective regulation of what we'll label better work. So with all of that introduction, Ron, I just want to help you over to the podium. And you've got the microphone right there.
Thank you, Gregor. And hello, everyone. It's lovely to see so many friends in the audience. Mary and I are very honoured to be giving this presentation on institutional experimentation for better work. And I know that this research project is global. We want to speak about Australia and some of the regulatory issues. I want to discuss the role of the Fair Work Ombudsman in enforcing minimum wage and hours systems in Australia. I want to look at the 7-Eleven convenience store scandal and the rather strange, limited amendments to the Fair Work Act dealing with vulnerable workers, which the Conservative government enacted, I think, somewhat reluctantly last year. Then Mary will examine the relatively recent phenomenon in Australia of temporary migrant workers. Australia has been a country of permanent migrant workers, but from the 1990s onwards, temporary migrant workers, and some of the problems that temporary migrant workers face, particularly when their visas run out or they lose their status or they break their visas conditions. And this again has added to what I will call the crisis in Australian labour law. Now, please forgive me, but to explain the peculiarities of the Fair Work Ombudsman and the position it is now in, I have to detour a little bit for history. I won't trouble you very long, but I need to go back to what we might call the classical period of Australian labour relations from 1900 to 1990, when we operated a system of compulsory conciliation, and where that failed, compulsory, final and binding interest arbitration. The labour courts in the early part of the century, which later morphed into Labour Relations Commission, the labour courts would settle labour disputes, and their settlements were embodied in documents called awards. And awards can be best thought of as labour codes, specifying for various industries and occupation, wages, work classifications, meal breaks, hours, holidays, etc. Now, it would have been nice in the early part of last century, in the early 1900s, if the arbitration court had been able to extend these awards throughout an industry, in the same way that many collective agreements, as I understand it, are extended in the province of Quebec, where we now are, or as in many other countries, the award could be regarded as the key collective agreement and could be made applicable to everyone in the industry. But the High Court of Australia in those early years, equivalent to the Supreme Court of Canada, held that the awards only bound the disputants, that is, the employers with whom the union was disputing and the members of the union. So in some ways they were private labour codes, and they were enforced generally by the trade unions. Trade union membership after World War I was somewhere around 50% certainly of male workers in Australia. And so they were settled often by union muscle, by walkout if you're not adhering to the awards. But litigation did occur, but in those days there was not a federal court structure. There was simply the High Court of Australia. And so, as Chief Justice Dixon once put it, we used a homegrown solution. He called it by the very complex Greek word of autochthonous solution. But basically, the federal law jurisdiction was granted to the local courts in all of the states magistrates' courts, to enforce awards. And enforcement was done on the basis of civil law, not criminal law. It was never perceived that employers who failed to pay wages in accordance with an award were criminals. It was simply done as a civil matter, almost like a small claims matter, and the penalties which were imposed upon employers and which the union recovered as a type of costs were simply regarded as civil penalties. By the Depression, and I won't keep you very long about history, by the Depression, the problem with awards was that the employers could dodge the awards by simply employing non-unionists and suggesting that they shouldn't join the union and we could pay them less than award rates. This caused the High Court, in an old case known as the Metal Trades Doctrine, to use a type of legal fiction and say the awards bind employers to pay everybody they employ the same wages and work rules as in the awards. Non-unionists weren't parties to the awards, but to protect union members, they had to be given the same wage rates and work rules. And given that non-unionists became involved in this type of labour relations, the federal government established the Arbitration Inspectorate, which operated for the next 60 to 70 years. Just as a digression, when I was a young academic, there was a scheme for academics to be seconded to the Federal Public Service for 12 months, and I was one of the first in Australia to be seconded, and I ended up at that inspectorate, which then went under the name of the Industrial Relations Bureau, quite pretentious, and I enforced awards. There was no great regulatory theory used at all. It was simply a complaints-based mechanism. If they weren't a member of the union, they couldn't go to the union, but they would come to us. More often than not, they would only come once they'd been fired. And I would say, well, you knew you were being underpaid. Oh yes, but I had a job. So why are you coming now? Because he fired me and I want to get every cent out of that SOB. The inspectors were not particularly trained. I was engaged in training. They tended to be retired union officials or retired members of employer associations, and because they understood their awards, they were able to play an enforcement role. Then came globalisation, which hit Canada as well as Australia, and we also saw deregulatory, or what you might call neoliberal labour laws, being utilised in Australia, perhaps in the 80s in Britain and the United States, certainly from the mid-1990s onwards. Also, with the changing of the nature of work, the increase in casualisation, union membership plummeted. Union membership now in 2018 is slightly lower than that of Canada. So from a union membership of 45% of the workforce in 1982, it's somewhere around about 17% now. Now, to again add layer upon layer, in 1996, the Liberal Party and National Party coalition government was elected to office federally in Australia. To put it most easily, these two conservative parties can be thought of as a conservative government. And it's governments which often gave the Arbitration Inspectorate their writing instructions. And the writing instructions in this new time of deregulation was, don't prosecute employers, use a persuasive dialogue, make sure that they perhaps play the game by paying back pay where they've forgotten, but don't use any regulation. We're into innovation, we're into deregulation. And so the Arbitration Inspectorate, which went under several names from 1996 to 2005, prosecuted 35 times. And here, and for the latter part of this work, I'm drawing upon some of the work of Tess Hardy, of my former student John Howe, and of another young lawyer, Sean Cooney, which is published in 2013 in the Sydney Law Review, and you can follow their other publications. In 2005, the Howard Conservative government went into full deregulation mode and deregulated our labour laws, which became known as work choices laws. For most employees, they lost their unfair dismissal rights. Many employees were forced off collective arrangements, and the public were very perturbed. Even people in secure jobs were worried about the types of jobs that their children or grandchildren would have access to, particularly with the changed nature of work and the falling in tariffs, etc. The Howard government was on the brink of losing the 2007 election, and so in May of that year, they lessened some of the harshness of the deregulated laws, and they said, look, we're going to make sure the laws are enforced, so we're going to establish what they called the Workplace Ombudsman, which is now the Fair Work Ombudsman. And in the second reading speech on the 28th of May, they said, we're going to give them $60 million immediately to beef up enforcement. And so for the first time, we had money going into a body to enforce Australian minimum wages. And in the second year of its establishment, from 35 prosecutions in just under 10 years, they did 77 in 1 year. And turning to the Fair Work Ombudsman, which was renamed the Fair Work Ombudsman when the Labor Party came into power in 2008, we have in Australia seesawing governments and tit-for-tat governments, is the best way to put it. The Fair Work Ombudsman was modernised. It was given power not only to enforce minimum wages, but to bring actions against sham contracting. That's when employers try to impermissibly turn employees into independent contractors. Instead of giving its civil penalty sanctions, it was given power of an enforceable undertaking. They're rather strange procedures, but simply you say to an employer, we know that you have failed to pay wages. We're not saying you're necessarily guilty, but we will prosecute. But instead of prosecuting, we want you to enter into a contractual undertaking that you will pay wages, that you will pay back pay. And if you enter into this contractual arrangement and breach it, it's like breaching an injunction. Well, by 2014, the Fair Work Ombudsman was enforcing wages more vigorously, but it was an old-fashioned agency. It didn't have any criminal sanctions. Remember I said to you that breaching awards was civil. It didn't have investigative powers where it could force people to answer questions. It had powers over documents. When you compared it with our body dealing with corporations, with securities, you look at it dealing with our body dealing with competition laws, with consumer laws, which were much more modern, they had the full range of sanctions from warning, advising, right up to a pyramid of criminal sanctions. Now, the Fair Work Ombudsman in these years began to adopt what we might call responsive regulation, the work of Ayres and Braithwaite. Basically, let's begin with advising, then harsher sanctions, and right up to all they had was civil sanctions. They began, rather than simply dealing with complaints and answering complaints, the old complaints-based mechanism, they began to run campaigns. They began to look at particular industries where they saw underpayment. This was a much more modern process of regulation, and in fact, probably they were influenced by an interesting person in the United States, David Weil, and they might call their work strategic enforcement, that they would utilise their resources to look at particular industries and where necessary to enforce. After all, litigation is expensive. Now, over the last 30 years, a cluster of federal courts have been established in Australia the Superior Court at the bottom and then the Federal Court. And now you started to have judges in the Superior Court who got familiarity with labour relations, and enforcement became a serious business. Now I have to turn to the 7-Eleven scandal. I think you have in Canada a series of 7-Eleven stores, so you know how they work. Well, after complaints in the media and exposés on television, the Fair Work Ombudsman decided in July 2014, just a few years ago, to investigate the franchising model of 7-Eleven. Mary will talk about this a little bit more, but they were playing games. Many franchisees were saying, we know, they were using student labour, migrant student labour. We know that you're only supposed to work for 20 hours a week on your visa or whatever. So we're going to pay you for those 20 hours, but you've got to work 40 hours. So you'll get half the minimum wage per hour if you work 40 hours. In some other instances, when they were asked to pay back pay, they would pay back the back pay, and then they would say, if you want to keep your job, here's our bank details, pay half of the back pay back into our bank account. So all these things were going on, and people in Australia, workers, began to get perturbed. They saw what they called wage theft. Our economy, while productivity was increasing, wages were stagnating. The collective bargaining system wasn't working particularly well, and in 2017, that is last year, there were fewer collective agreements signed, or only as many signed as were signed in 1995, when collective bargaining was at its infancy. The Australians were feeling very troubled about wage theft, about their children in various jobs that were being screwed. And so the Conservative government, which had got back into power, very reluctantly passed the Fair Work Amendment Protecting Vulnerable Workers Act last year. It was lobbied against passing the act, or certainly the act to be toned down, by the franchisors, who have a very powerful lobby. Briefly, the act, most importantly, increased the powers of the Fair Work Ombudsman. After its inquiry into the 7-Eleven stores, the Fair Work Ombudsman said, look, it's very hard for us to gather evidence. We can't compel people to answer questions. The way they actually gathered evidence was very smart. Where pay records were not not able to be got, they were hidden away or weren't even made, they would examine the CCTV footage of who was actually manning the store at a particular time. Employees had to punch in a number when they were manning, and so they got the computer records. But they said, look, we can't do anything unless we have powers. And so the amendments gave the Fair Work Ombudsman significant powers of being able to ask questions, being able to dodge around the privilege of self-incrimination, etc., and it's given it a new lease of life. Other things they did, they made it easier to make franchisors, that is the ones that run the franchising, liable, but the steps there are so complicated that I think it will be difficult to make them liable. And finally, it increased penalties significantly. When awards, the old awards were civil and run, penalties were low. As late as 1994, the maximum penalty for not paying people properly was only $1,000. Now it's been put up to, I don't know, for an individual $60,000. It's all in penalty units. But I think the weakness in the legislation is that it doesn't strike at the heart of franchising and certain supply chain operations in Australia. As I read the franchising, and I don't want to single out 7-Eleven, but most of the franchising contracts, the franchisee has very little room to manoeuvre. That is, the people that buy the stores, for example. They have very little room to manoeuvre. It's the franchisor that sets the patterns, where the furniture is, what goods you display. And I think it's these models, or some of them, which push franchisees in desperation, some of them, to cut wages and to play these games. And I think if you really want to get serious, you have to think about making the franchisor model responsible when significant and systematic wage infringements occur. I think, and I was talking to Kevin Banks at Queen's University yesterday, I think we have to think, if we're going to look at modern regulation, we have to look at who are we going to hold responsible for ensuring that wages are paid. It does not always need to be the immediate employer on the ground. In supply chains, in franchising arrangements, we may want to rethink. And just to conclude, because I want to give Professor Crock plenty of time, she's far more interesting than I am, it will be interesting to see how this Fair Work Ombudsman, which was was set up by a conservative neoliberal government when it was desperate, and now had its powers increased because of media and worker concerns, to see how it handles its new powers, how it will operate in relation to strategic enforcement, whether we will see lessening of wage theft in Australia. Labour law in Australia at the moment is in a crisis. It will be very interesting to see how the Fair Work Ombudsman and other institutions experiment to ensure that Australian workers get a fair deal. Thank you very much. Thank you.
Thank you, Ron. Thank you, Gregor. It is always such a pleasure and an honour to be with you, and I think this is my first time that I have lectured to CRIMT, so it is indeed an honour. I am a migration lawyer, and I have an interest in particular in vulnerable workers, and that has drew me, vulnerable migrants rather, which has drew me to do a lot of work around refugees, but also to look at the situation and problems faced by temporary migrant workers. Now, as Ron said, the whole idea of bringing temporary workers to Australia is relatively new. It's very much a product of the General Agreement on Trades and Services, which was first negotiated by Australia in 1996, interestingly by a Labor government, but then introduced by the more conservative Liberal coalition. Australia, you may be aware, came together as a country in 1901, so we're very young as a country. And we are a country that was very much founded in racism at one level. The White Australia policy was one of the key pillars of the country. What people are less aware of, though, is that there were really three pillars. White Australia, free working Australia, the tariffs that they introduced to create the new country was the third pillar. But at Federation in 1901, the very first piece of legislation that was passed by the new federal government was legislation to remove contract migrants who were working in the cane fields in northern Australia. So the Pacific Island Labourers Removal Act was Act number 16, the first piece of legislation passed after the creation of the Australian Parliament and functioning of government. And the reason for that was Australia was established less than 50 years after the end of the Civil War in America. We took some elements of the government in America and some elements of the government in Canada when we created the new country. But we were very aware of the problems that flow if you have a two-speed or two-tier economy based on slave labour. Hence, we wanted to get rid of the contract, the slave labourers effectively from northern Queensland. At Federation, they therefore decreed that migration to Australia should be permanent migration. We actually couldn't agree on a concept of citizenship. So immigration law ended up doing a lot of that work, who was in, who was out, and who we accepted and who we didn't. But if you have a look, Section 3 of of the first legislation decreed that you would be a prohibited migrant if you came into work without the permission of the minister on a temporary basis. And therefore, all of the structures established to protect workers in the first instance, and that continued to be the case, really, until after World War II. In 1958, we dropped the White Australia dictation test, as they used, and moved to a more modern discretionary migration system. But it was as difficult up until that time to bring in a temporary worker as it was to bring in a person of colour, which I think is really, really interesting. And the thinking behind that, which is set out nicely in an article by Lenore Lehman, that she called "To Keep Up the Australian Standard," was they recognised that if you wanted to have a labour system that was fair and free, yes, it was white, but that was free, you had to have a standard for Australian workers that applied to everybody. And they enforced it. They absolutely enforced it. So what is interesting is that the trade unions, which were so much part of that labour history, and the cognate legislation operated to continue the exclusion of temporary workers and persons of colour all the way through. And in fact, until very, very recently, trade unions in Australia were not the friend of migrants at all. And I think one of the most interesting structural changes that we've seen happen in Australia is the extent to which the traditional frameworks for the protection of workers have realised that in this day and age, with dwindling trade union membership, that migrants actually represent an opportunity rather than a threat. So that's very interesting. I want to talk today about the changes that have occurred in the migration and the use of temporary workers in Australia since 1996, and look at how the numbers have changed for starters. It's now said that up to 12% of the workforce in Australia is comprised of migrant workers. Education, of course, has become one of our major export earners, and for anybody coming in to do courses longer than 6 months, a year, up to 4 years, those people will automatically get a right to work. But the really massive change has been the philosophical realisation that temporary migrant workers are necessary for the development of a country. And so it's really, since 1996, we've had a series of legislative models used to regulate temporary workers, temporary migrant workers. Those are interesting in themselves, and I probably haven't got time to go into them in any great detail. For example, in 1996, at the start, they really played with this idea of, well, who should dictate who is needed? Should it be the employer or should it be the government? And in the beginning, it was very much driven by the employer, saying if you could show that an individual was bringing in to do a quote unquote key activity within a business, then you could bring the migrant in. They had to be highly skilled, but that phrase was really left to the courts and other agencies to define. What we've seen in recent years is the government coming in and the statisticians coming in and saying, we will look for job vacancies and that will dictate who is needed. We now have a system which it's not as unique as it used to be, but when I was doing some comparative migration law work, I realised just how much of an outlier Australia is. From 2000, we have actually articulated occupations, what is required to work in an occupation, in a document that's generated by the Australian Bureau of Statistics. So it tells you what you have to do for each occupation, we've specified that in order to come into Australia, you have to be job ready. You have to show you have these qualifications, this experience that are recognised in Australia. So with one stroke of the legislative pen, we got rid of the failure to recognise overseas qualifications. But then we went further to actually look at job vacancies, and we asked the labour departments to tell us what the vacancy rates were in all these different occupations, and then we created lists. Now, for the temporary workers, the list was a long one. As of March of this year, that list is going to be very sharply shortened, but we have a really very definite, distinct way of working out who's needed in Australia according to what jobs are available. So, why is temporary migration an issue for the protections and the vulnerability of workers? Well, the thing is, if you break the law, if you commit a criminal offence, all migrants, permanent and temporary, are vulnerable. They can be removed from the country, and it's an issue in Australia as much as it is in Canada and in America. But if you're a temporary migrant worker, ipso facto, by definition, your tenure in the country is limited. And the problem is it creates inherent vulnerability, because if you're a student, for example, you're only entitled to work according to your visa for 40 hours across a fortnight, effectively 20 hours a week. And as Ron just described, the problem is that many of these franchises, like the 7-Eleven and similar organisations, they look for students. They look for the low-paid people who are prepared to work for very little amounts. And they do it for two reasons. First, they'll take less money, but they know that their status creates an inherent vulnerability in the sense that they won't complain. If you don't pay them the right money, they're not going to go and complain, because their status, their tenure in Australia is at risk. And they're basically there to get their qualifications. So they have a lot to lose if they don't. So I've written a paper recently, I should add, in addition to the students, the 457 visa class, which is the code that you now use that covers the biggest group of temporary workers, they're also very vulnerable, because under the law they are required to stay with a particular worker, with a particular organisation or employer. They lose their sponsorship by the employer. They have 28 days to find a new employer, but it's not going to be easy to do that. And particularly in more remote areas, in more high-pressure industries, it's going to be hard to do that. So temporary status really creates vulnerabilities. What I want to do with you now is to actually look at what the structures in Australia do to those who fall outside of the law. And as I've tried to explain, that's not hard to do if you're a student, if you're on a temporary visa. We have about 50,000 people in Australia who are actually humanitarian migrants who are also on temporary visas. They have full work rights, but they also are vulnerable because any behavioural breach can put them at risk of having their visas cancelled. So we're a country, interestingly, that has been able to control migration much more than virtually any other country around the world. We are the only country in the world that has no land borders with any other country. We are both a country and a continent. And to get to Australia, you either have to take a boat or fly in. And that is reflected in the fact that statistically we have counted less than 60,000 illegal migrants or unlawful non-citizens, which is what we call them now. In recent times, with this move towards more and more temporary migrants, what is interesting is that in global terms, our illegal migrant population remains very, very low, but it has risen about 4% in the last 5 years. So however small those numbers are, the shift to temporary migration actually is reflected in an increasing number of people falling outside the law, labouring outside the law. So what structures are available? What are the systems that are available? I want to look at two contexts where illegal work, I actually hate the word illegal, so where unlawful non-citizens are injured at work and where they are abused at work, which is what Ron has really been talking about. In both of those circumstances, a central problem is their unlawful status, their status as illegal worker. The traditional approach was to say, which was very much tied, as I explained before, to the idea at Federation that that workers coming to the country should come as permanent migrants and therefore be treated like everybody else. In the first legislation, the provision in question, it was section 11 actually, it read that no contract or agreement made with persons without the Commonwealth for such persons to perform manual labour within the Commonwealth, whereby such persons become prohibited immigrants under the meaning of section 3G of the legislation, shall be enforceable or shall have any effect. In other words, the first legislation actually said you can't contract with these people. They literally work outside the law. And therefore temporary workers in the early days literally were invisible and they had no right to enforce what was going on. Flash forward to today and what the Migration Act, as it is, has a provision in it which prohibits work by people who don't have the right to work in Australia. And I'll just read it to you. Section 235 prohibits work done in contravention of a condition on a temporary visa. Subsection 5 prohibits an unlawful non-citizen from working in Australia for reward or otherwise. So if you don't have permission to work, you actually you commit an offence, and it's a strict liability offence in the sense that even if you don't know you're doing it, you can be liable. But it doesn't actually say that contract is completely void. So what is interesting is we've seen a real divide open up in the way the courts have been treating people who are found to be working outside the law. If a worker is injured at work, the old approach, but still persisting in some contexts, has been to say, well, the contract of work was illegal and therefore there is no contract and therefore there is going to be no compensation payable. What is interesting is that we've seen two things happen. First, some states have become more progressive than other states. And interestingly, our present home state, New South Wales, is one of the most progressive states in Australia, together with Western Australia, interestingly, where I was born, right over the other side of Australia, with the southern state of Victoria a little bit between, it's actually between the progressiveness of New South Wales and the very old-fashioned approach that's taken in Queensland, which is up above there. But so the problem with the workers' compensation, which operates when somebody is injured at work, is that it's tied to the definition of worker. And so the argument made in the more traditional states has been, you're not a worker. You're not a worker unless you have a lawful contract, a legal contract. The common law will say that there is a doctrine of illegal contract, and it operates to make any purported contract void or unenforceable. In New South Wales, Section 24 of the Workers' Compensation Act says this, I'll read it to you. If in any proceeding for the recovery of compensation under this Act, it appears that the contract of service or training contract under which the injured person was engaged at the time when the injury happened was illegal, the matter may be dealt with as if the injured person had at that time been a worker under a valid contract of service or training contract. May be treated. Interesting, because it actually provides a discretion in the Commission or the court to give a remedy. Interestingly, in New South Wales, there is a discretion to make a payment for weekly compensation to continue even if the person leaves the country. Now, you see, I was invited to speak a little while ago to a group of experts in workers' compensation, and I began at the start to say, well, have any of you worked with illegal migrant workers? They sat there, said nothing. They said nothing. The truth is that we often, when we see somebody who's injured, we see somebody who's injured. We don't think about their immigration status. When I pushed them further and talked to them about migrant workers who were injured, they literally hadn't thought about their immigration status. When pushed further, they said, oh yeah, lots of times, and you know what the biggest problem is? They all get chucked out of the country, and so we can't act for them anymore. They get removed, they leave, they have to go home. So the power, the ability to actually get compensation for somebody, even if they have gone back to where they've come from, is actually a very important one. And the Victorian legislation doesn't have that in it. It actually says as soon as a person is removed from Australia, then any payments will cease. So New South Wales, I think, really is quite visionary in that sense. Okay, so I just want to say, because Ron has spoken for some length about the exploitation of workers, one of the interesting things here for me is the extent to which it seems like the wheel has turned completely again, and we are beginning to realise that if we do not protect the most vulnerable, we all suffer. And so it is that the trade unions today have seen that migrant workers are very much an opportunity for them, new constituents, important constituents. The Fair Work Ombudsman, it was set up as an agency to deal with workers. Again, it could have taken the approach of the old legislation to say, these people are working outside the law. They are illegal workers, therefore there is no contract. But they don't do that. The Fair Work Ombudsman has actually used, has seen the temporary migrant workers working inside and outside the law equally as worthy of protection. And it does interest me that the amendments to the Fair Work Act I think very much a reflection of the pressures, the political pressures that can be brought to bear when you have investigative journalists who put this in your face all the time. I don't know if you have seen that new movie that's just been made, The Post, but really the media, I guess in some ways as has ever been the case, but today more than ever, where you get unions and investigative journalists working together for justice, you can really see what can be gained. And for migrant workers, they have absolutely benefited 110% from the vulnerable workers legislation that's recently been passed. So that brings us up to the end, and I'll take questions on our book, I suppose. Yeah.
Thank you so much, Mary Crock and Ron McCallum. We have a time for questions. Il faut souligner que nous avons la possibilité de poser des questions en français. On va les traduire ou Mary va les comprendre, comme vous pouvez poser des questions en anglais ou d'autres langues. Et on aura des gens qui peuvent formuler des questions aussi. Exemple en chinois, Ike et Meiyun vont nous aider à ce propos. If you have questions in Chinese that you want to ask, we'll have someone translate them as well. And we also have people outside the room who are viewing this on the YouTube channel. I especially want to thank Nicolas Roby and those who have worked with him, Amélie, to make this happen. This is an experiment, and the people are telling us online that the quality is really excellent. So thank you, and people will also be able to see it afterwards on the YouTube channel. So no, not at all, because some people had said they really want to see it. They're teaching, but they can't be there right now, but they'll do so afterwards. So with that in mind, I think that Judith has some microphones there, and so anyone who wants to raise their hand, very informal discussion, and anyone who wants to ask a question and is on YouTube, you have a box there and an email address, and you can send a question. Nicolas Roby will pick it up and relay it to me, so people outside the room can also ask questions. So I think that there's a very timid Michel Coutu who would like to ask a question. Don't be shy, Michel.
I will try. Please don't be too rude with me. I will have a question for Ron and or Mary, and a commentary for Gregor. Question for Ron McCallum. You certainly remember me, Ron. Michel Coutu from the School of Industrial Relations. We've met a few times, and it's always a great pleasure to see you again. And now we have a newcomer from, and you are Mary. It was very interesting. My question is, you know that you certainly know that in Canada we have a process of, I would say, constitutionalization of labor law, especially at the level of the Supreme Court of Canada, with the recognition as a fundamental human right of collective bargaining and also the right to strike, in reference with ILO convention, especially 87 and 98. So I would like to ask both of you, is there some kind of similar development in Australia? Maybe not the same, but okay, that's my first question. And I have a commentary for Gregor. I think that when we speak of institutional experimentation, and these conclusions come from, to me, from hearing Ron and Mary expose, I think we have to focus, yes, on the, let's say, a specific regulation, experimentation by courts or government or markets, trade union, and so on. But we have to place that in a bigger context of experimentation in the past at the state level, and it is still the case, but also at a global level. So I think we have to toujours to imbriquer l'expérimentation institutionnelle à un niveau organisationnel ou judiciaire, etc., l'imbriquer dans des changements au niveau de la société, soit de l'État comme tel, soit de la nation, soit de l'État-nation, soit la globalisation, changement au niveau de l'expérimentation plus globale sur le plan économique, par exemple. Petite réflexion.
See, just to translate quickly the last part of Michelle's comment in saying the need, when you're looking at institutional experimentation, to think of what's happening at an organizational level, but also to upscale it to a societal, an economic, even a global level of other kinds of experimentation that's taking place, and to embed your understanding of that experimentation in something much broader. Is that a fair?
Yeah.
So I'll pass over to Ron, and when Mary wants to pick up the question, she can put the microphone light on. You've got your mic on here.
I'm sure she will want to pick up. The short answer, Michelle, and it's lovely to see you, and I remember our long chats at Université Laval in Department de Relations Industrielles. The short answer is no. We have no constitutionalization of labour law as you have. Relying upon your case law is relatively recent. Dunmore, BC Health, Fraser and Saskatchewan, Mounted Police. It's where you rely upon Section 2D of your Charter, Freedom of Association, and you bring in Convention 87, and through Justice Abella, you bring in the right to strike. There is no such, we don't have a Bill of Rights, as Mary will tell you very eloquently, and we don't rely upon ILO conventions. I think Australia has the second most complaints about the breach of ILO conventions. Canada is still in number one because it's only recently that you've had that. Our strike laws are as stringent, or our anti-strike laws are as stringent as the Thatcher government laws. Give you an illustration. There was going to be a 24-hour rail strike in Sydney the Monday before last. No, in fact, this Monday. On the Friday, the Fair Work Commission, using a power it has to say it will suspend industrial action where it's going to affect the national economy, said that a train strike of 24 hours would affect the national economy and suspended it. And if workers went on to the 24-hour strike, they would be fined. Now, I can't imagine that being done to government workers in Canada, where you would suspend, not on grounds of national emergency. It has in it akin to your back-to-work legislation. And although you have a constitutional right to strike, when I look at things like your back-to-work legislation with Canada Post and, more interestingly, Air Canada, I think you've still got a way to go to work out in your system what you really mean by the right to strike. But we have no protections at all. We breach ILO conventions willy-nilly, and our workers are chained by a forest of unfair laws.
Yeah, I totally agree with that. And in fact, in some ways, I think this is very much a hangover of the failure at Federation to establish an Australian citizenship. Instead, citizenship in Australia at Federation was almost like the hole in the donut. It was everybody who was not excluded from the country. And the argument was made, we don't need citizenship because we're already citizens of the States and we are British subjects, and that is enough. But if you can't say who was a citizen, they couldn't, ipso facto, couldn't say that the citizens had rights in the country. And I see this very much as a hangover from that. At the same time, though, we have been affected by globalisation in positive and negative ways. Negative ways, we have copied the US like there's no tomorrow, and adopted the US practice of saying we will dictate what the law is, we being the federal parliament, and only the federal parliament. So you end up with this Janus face. We like to hang with the UN people and we like to be part of the UN system, but when it comes home, when it comes to the rights of migrants or of workers, then whatever happens in Geneva stays in Geneva, honey, you know? Certainly we understand obligation and the concept of obligation, but not rights. We won't talk the language of rights. And if you do in Australia, if you start talking rights, you just see the curtain come down, the shutters come down. So you always have to turn around the other way. And this is where the globalisation has had a positive effect. We talk to the other countries. And so what we do see is you see borrowings, and this is something I'm sure you'll be looking at with your project. And I've just had a doctoral student who looked at migration borrowings, but transfer of policies across countries, very interesting. It's like a Mexican wave. If you see one country introducing work laws, particularly if they're electorally effective, you will often see other countries come in and say, oh, well, you know, Theresa tried that, why don't we have a go? And so you see the laws travelling around the country. When I started, I mentioned before the use of these very codified occupation lists. That, in fact, the use of points test is something that started in Canada, interestingly. Well, actually didn't, it started way back. But you see that moving around the country, around the world, very interestingly. And often the academics are not really aware of it. So I've been trying to advocate over the years that we start doing what governments are doing. They've got their officials who are talking to each other all the time. It's about time we did the same.
And I'll just mention that in a background, there's a very interesting book by Jamie Peck and Nick Theodore called Fast Policy. And this is really about neoliberal borrowings. In other words, the speed with which you have neoliberal experimentation. And of course, we're thinking here for better work of other kinds of experimentation. So making exactly the same case as Mary is here. Now, d'autres questions, other questions, please feel free. Il faut se sentir libre de les poser dans la langue de votre choix. Et ça peut être des questions larges, comme ça peut être des questions précises. Questions, anyone?
Pose-moi une question en français. J'aime pratiquer mon français.
The micro, just for posterity and the listeners outside.
I'll speak to you in French, Mary later on. I want first to thank you, both of you, for this presentation, which has been very, very interesting. And I'm not sure if I've understood everything. But Mary, if I ask you in a nutshell, as of today, the legal and actual, factual situation of migrant workers in Australia. Are migrant workers better off today as in the old time when they weren't really considered and they were falling outside of the law? Is their situation better off now?
Well, the point I was trying to make about the beginnings of Australia is that there was no concept of the migrant worker. You were a part of the community as soon as you entered if you were white, and you were employed by a company as a permanent worker. So there was an interesting case in 1905 where a hat-making factory in Melbourne wanted to bring in some temporary workers from Manchester in England to teach people how to make akubra hats with the rabbit skins and everything. And they were excluded because they were trying to do it to break the unions, to break a monopoly. And it's interesting that because we were such a tiny country, the temporary contract working legislation was really introduced in recognition of the fact that you needed a monopoly. You needed to allow monopolies in businesses for companies to survive. So the short answer is that there were no temporary workers to speak of, really. They were not allowed into the country. And the history of labour regulation applied equally. So everyone was a migrant, basically, in those early days. If you look more recently, I think we really are a country that has been able to control migration so minutely, that it is probably true that there has never been a true underclass of migrant workers, possibly until recent times with the explosion in the number, between 12 and 15% of the workforce being temporary workers. That creates considerable vulnerability, and I think it's the plight of the migrants that has really pushed a lot of what Ron was talking about. It's often not acknowledged, but in many respects the tail has begun to wag the dog. That the migrant workers are the ones who are 100% represented amongst those who are being killed and injured and exploited in these franchises.
Can I just ask Ron or Mary just a little more detail on where the Ombudsman or the Ombudsperson came from? If the legislation prior to the reinforcement of those powers originally foresaw a role for an ombudsperson, because often an ombudsperson is an exceptional recourse rather than a regular recourse. So I'm interested in a piece of legislation that, in a sense, says
National Ombudsman is the person who was the one person who would fight the bureaucracy. In Australia, as in other countries, we've seen a proliferation of ombudsmen, from ombudsman for telecommunications, ombudsman for consumer protection, and they've ended up large bureaucracies. When the Conservative government was in a crisis, thinking it was going to lose the election, its hard heads thought of branding. They said, let's call this new agency the Fair Work Ombudsman, and we'll simply take the old Arbitration Inspectorate and we'll rebrand it with this name. And that's why when looking comparatively, you've got to look at a functional thing. If you look at the Ombudsman as just a general word, you think, well, that's a very special person. But you've got to look at what they do, and it's nothing more than a big bureaucracy, but it's now been given power, and it's now become politically more acceptable to enforce wages when we're seeing large areas of wage theft amongst migrant and unskilled workers. So it's really somewhat akin to your ministries of labour run by the Deputy Minister. but it's just using the word as a brand, as a comforter to Australians, saying, you've got this special body looking after you. Language in politics is so very important.
Can I add to that? In the migration area, the Ombudsman is used to oversee immigration detention. And I have another perspective on the Ombudsman. Ron is, of course, completely correct. Really, in the Labor space, this is really about branding, and it's about the relabelling of bodies who already existed. But if you stand back further and look at the role of ombudsmen persons, whatever you call them, in Australia, the Ombudsman, of course, is a word that comes from the Swedish agency that was introduced as an oversight mechanism for government. And its proliferation in Australia, I think, is particularly interesting because of the fight that has has been joined between the courts, the courts and the Parliament. The fight has occurred in labour relations, but very, very much in immigration. And it's very interesting that you see, in many instances, oversight that used to happen by the judiciary being replaced by the Ombudsman. And an Ombudsman in the Australian system is an organisation that is not judicial and very often does not have binding powers, but answers to Parliament and makes recommendations to Parliament. Now, I think the Fair Work Ombudsman has got a life of its own. It is interesting that they've used the language of Ombudsman and dropped it in there. In the immigration context, it's all about not going to the courts, and it's another story, but it's very much part of the feeling in Canberra that the power should be vested in the people who are elected 100%, and they don't want the power to be exercised by the courts, even though, you know, we're supposed to have a system where the courts stand as a check on the balance of in the exercise of power. The Ombudsman is this mediator in between organisation that is palatable to the parliamentarians.
Gilles.
And how much independent the Ombudsman is from the government, because he's responsible before the Parliament, so he's very independent from the government?
They are very independent, and it's very interesting. Ron, you might have a view on this, but in my experience, they do tend to be very independent. It depends on who is appointed to the position, obviously.
Well, when you're dealing with the General Ombudsman in Australia, federal and state, they are independent, they're statutory officers, but using the Fair Work Ombudsman label in labour relations, they are not independent in the sense that the minister can give them writing instructions. It can't give them total writing instructions, but it's not the independent arm's lengths that we know of General Ombudsman.
Yep.
So they're misusing the label. And so, yes, to go back when the Conservative government was running the Arbitration Inspectorate and it did 35 prosecutions in 10 years, that was due to writing instructions from the minister that I couldn't get hold of under freedom of information legislation. I think that in the current political framework, a minister couldn't give writing instructions to stop and hold prosecutions, but governments can use their funding, powers, and limited writing instructions to lessen the capacity of agencies if they want to. The General Ombudsman have independent, separate budgets, and they're in a better position.
D'autres questions? Other questions? Yes, please take the micro and identify yourself as well. Okay.
Hi, sorry. My name is Julian. I'm a master's student here in international law. So I have one question, maybe for Mary.
Sure.
From Mary Crock. Question about the gender dimension. Is there any like focus or trend that the Fair Work Ombudsman is looking regarding questions of sexual harassment that is experienced by temporary migrant women workers? Is there any focus on these questions, or like is there any gender dimensions in the research or in the prosecution of in the work of this Fair Work Ombudsman?
Maybe me for a little bit.
Yeah.
The Fair Work Ombudsman does have powers over what is called adverse action at work, which covers areas of harassment. I'm unaware of any general research looking at that area, but it's very clear that in the area of temporary and precarious work, it's very gendered in Australia, with the bulk of that work being done by women. We've been away from Australia for quite some time, and the Me Too hash, I'm not sure what's happening in Australia. I find it quite extraordinary what's happening here in Canada. I don't think we've reached that extent in Australia, for good or for ill.
I might just jump in here and say that there was, I've just recently written a paper that is under consideration for publication at the moment that covers a lot of what I was talking about. And at the very end of my paper, I actually look at another structure that's been set up that is used in Canada and in the US, Australia, all around the world. And that is the trafficking legislation. And in the context of sexual servitude and abuse of women in particular, not exclusively, but typically women, the laws have been changed to allow for remedies, including immigration remedies, for individuals who have been subjected to trafficking. That is, and the tie-in with temporary migrant workers there is that trafficking is defined as any continued relationship between the trafficker, the person facilitating your admission into the country, and behaviours and treatment after you enter the country. And the typical story that you get is a woman who's being brought into the country but arrives with a massive debt that must be repaid, and very often the trafficker then will work with an abusive employer to, and very often in the sex trade as well, in order to pay off that debt. So, like as Ron says, I think this Me Too campaign and the focus on the abuse of gender relationships or sexual relationships between individuals is going to have an impact. In the case of trafficking, it already has. And in our part of the world, in Southeast Asia, it's a very big issue, as it is, of course, in Central and South America too, here, going into America.
If we can just close the microphone. Y a-t-il d'autres questions? Any other questions? Otherwise, I'll bring this to a close, this very interesting seminar. We have been talking in recent meetings and amongst ourselves about inherent vulnerabilities and the intersectionality of those vulnerabilities, which is certainly a theme in the book edited by Mary and Ron and their colleagues Laura Smith-Cann and Ben Saul, about the legal protection of refugees with disabilities, forgotten and invisible. And I think that what we've heard today is this question of inherent vulnerabilities and the relationships to sets of rights. We heard white Australia relative to persons of color. We heard permanent versus temporary workers. And doubled over to that is a question which we probably consider less, and yet it's at the core of what Mary is looking at. And if you are working in China, then you think about this, which is, what is your residence status? Do you have hukou? Are you a refugee? Do you have citizenship? how are you defined in relation to territory? Julien brought up the question of the gender dimension and the adverse action at work. Warren responded. And then, of course, there's the question of your age, and Mary in particular has looked at children, refugee children, unaccompanied minors, so the minor major aspect. And we also heard today, of course, the question of disability or without disability. If you are a refugee with disabilities, you are forgotten and invisible quite often. And then we heard another expression which resumes it in some respects. Is it inside or outside the law? Lawful or unlawful? So we have this whole combination of things that we want to keep in mind at the same time, want to make sure that there aren't blind spots, because the relationship between vulnerability and rights has to cut across those different dimensions. So I really want to thank you for bringing this to our attention, Mary and Ron, in a very stimulating talk, which we'll continue to listen to. And I think there was another aspect which is very interesting for us, and this is the role of the media and also social media in relation to this. And you mentioned the role of the media in 7/11. If we look at labor rights in China, it's quite often the role of the social media and how this bubbles up. If we look at the legislative reform package in Ontario, then it's a question. There was a number of articles, a series of articles in the Toronto Star on temporary employment agencies and the abuses inflicted upon temporary employees in the context of the Ontario law, which was really a spur to this. So we need to think as well about the change process in relation to media and social media. So with that in mind, I really want to thank you both. Speaking of hanging around the international bodies, Mary will be speaking tomorrow at the UN in New York to one of its committees, considering the rights of refugees and migrant workers, refugees and migrants, I believe. Yes. Okay, she's talking about the book, which I think has already been plugged, so we're okay. So thank you very much, and see you again soon. Thank you, and thank you for Nicolas for arranging this for our YouTube audience and beyond. So thanks very much, Ron and Mary.